two, one, two, three.
Hello and welcome to Ithaca DSA Presents. I'm Theresa Alt. I'm here today with Gabriella da Silva Carr. She's the Associate Coordinator of the Tompkins County Workers Center. And we will hear about what she and the Workers Center have been doing. Gabriella, what were you teaching at the high school?
I recently participated in a week of events called Social Justice Week at Ithaca High School. Folks from the community were invited to give presentations on relevant social justice issues. And obviously they thought of us at the Workers Center. So they approached us about offering a training to the young people around their rights in the workplace, like a Workers' Rights 101 event. And, they had questions like every other slide, and they were bringing up their experiences in the workplace. And then staff had questions afterwards. So it made me realize that there's actually a lot more education that we need in our community for people to really understand what rights they do have so they can self-advocate as well as use the power of collective action in the workplace.
And if somebody from somewhere else wanted to arrange a similar session or had a question without even seeing the presentation, how can they reach you?
Yeah, so there's a bunch of different ways to get in touch with the Workers Center. So if someone was interested in a worker rights workshop or training or seminar of some kind, they could directly reach out to me via email at Gabriella, Gabriella @TC workers with an S center.org is one way. Another way is that you can always go to our website, which is tcworkers with an S center.org. And on that website, you will also find the phone number for our office as well as our worker rights hotline. It is a warm line, so leave a voicemail and a representative will get back to you from the hotline, one of our advocates. The hotline phone number is 607-269-0409. On our website, there is a form if you'd prefer to submit your worker question or, what you are interested in inquiring about. There's a form you can fill out on the website, as well as we accept inquiries via email. So you could send it directly to my email that I previously stated, or you could send it to the Worker Rights Hotline email, which is TCWRH, which stands for Tompkins County Workers' Rights Hotline. So TCWRH at tcworkers with an S center.org.
Let's also go into a little bit of the content of your presentation. And I hear that the first part was about hours and wages.
Yes. So in New York State, when we talk about workers' rights, we always want to start at the basics, which is what is minimum wage in New York State? Currently, minimum wage is $15 an hour in Tompkins County. So no employer can legally pay less than $15 an hour unless we're talking about tipped workers, which has a lower minimum wage, which we'll talk about in a moment. Something else to mention is overtime. Overtime in New York State is required for all hourly employees who work more than 40 hours in the same work week. Once an hourly employee has worked at least 40 hours in the same work week, they are entitled to overtime pay, which is 1.5 times the worker's wage. So if you're working minimum wage for $15 an hour, your overtime rate is $22.50 an hour.
My experience is that the simplest and justest way for a workplace to have a little flexibility, you might say, without incurring overtime, is to have a work week that is only 35 hours long.
Absolutely. Yes, we would definitely say that, we know historically from data, from studies, that the more hours per week someone works, their life expectancy decreases. Once people are working more than 35, 40 hours a week, there's a negative impact on quality of life. It increases chances of diseases and illness. And so, there are places, throughout the country that are starting to experiment with the four-day-a-week work week instead of the 5-hour. And there are employers, who are considering, I have a friend who is a full-time employee, and for them, full-time employees are 35 hours a week and get the same salary as folks at most places that work 40 hours a week.
There are some extra things to know in the food service industry.
Yes, when we talk about tipped workers, which is most often in the food service industry, there's a different minimum wage. It's called tipped minimum wage. And the tipped minimum wage in Tompkins County is currently $10 an hour. And under minimum wage laws in New York State, a worker's cash tips must equal at least $5 an hour average for the shift, or the employer has to pay a pay wage differential. If the tips average out for less than $15 an hour, the employer is required to pay the difference to ensure your paycheck was a minimum of $15 an hour. And overtime laws do apply to tip workers. So once a worker has been working 40 hours in the same work week, that tipped worker must now be paid at least $15 an hour plus tips, right? If $10 is the tipped minimum wage, 1.5 is $15 an hour.
Another area that is sometimes a little different is what's called the gig economy, or being an independent contractor.
So I think, there's a lot of articles, a lot of talk nowadays about the gig economy, right? These are folks who are not being employed at one employer, receiving a annual salary that provides a full ability to afford one's life. Gig economy workers are going from gig to gig, right? They're going from client to client. Examples of gig workers are people who work for Uber, delivery drivers, self-employed entrepreneurs, folks who are consultants. These are folks, right, that are only getting work as long as they contract with another business or organization or individual to have work. So they don't have the same guarantee of consistent income. They don't have the protections that workers who are hourly or salaried employees get. So gig economy workers do not qualify for unemployment insurance benefits. Gig economy workers are not protected by a workman's comp policy that belongs to their employer, right? Because they are employed by themselves and working in agreement for someone else. And for contractors, it's really important to know whether or not you're being misclassified. Because as an independent contractor, you must, one, have a strong degree of control over your work. So you must be able to choose your own work schedule, choose your own job responsibilities, and you need to be able to do that same kind of work someplace else without an issue. So you need to be able to have control of your time and how it's being used. Another thing that is necessary to be an independent contractor is that the worker has to have an opportunity for profit or loss. So for example, if I'm an Uber driver, I have to supply my own car. So I'm investing in an asset that I can potentially gain or lose money on, right? Because if I get into a car accident while being an Uber driver, Uber's not going to pay for my car damage. I'm taking on that cost potentially because I chose to be a gig economy worker. I am now risking taking on a debt as a result of this work. So you need to have both these elements to be classified as an independent contractor in our work economy. And people often don't realize, Theresa, as well, that being an independent contractor doesn't mean that you don't qualify for overtime pay. Independent contractors must be making more than $1,124.20 a week for them to no longer receive overtime wages. So if someone's an independent contractor and they're working for, minimum wage, $15 an hour, that person would still qualify for overtime after 40 hours in the same work week. And that's something independent contractors don't know. That they do still have a right to overtime pay.
I certainly hadn't realized that. Another form of protection in New York State involves discrimination. So perhaps you could tell us a little bit about that.
Yes. So, New York State is one of the stronger states in the United States when it comes to discrimination protection in the workplace. In New York State law, you are protected from discrimination in areas such as employment, education, credit, purchasing or renting a home, commercial space. So it doesn't apply just in the labor field, but in many areas of our society. And in New York State, that includes race, ethnicity, religion, skin color, national origin, sexual orientation, gender identity, gender expression, gender presentation, sex, age, marital status, whether or not someone is a domestic violence victim, whether or not that person has a disability, immigration or citizenship status, pregnancy, related conditions and status, predisposing genetic characteristics, whether or not someone is justice impacted, any convictions on their records, protection from retaliation for speaking up against discriminatory practices.
Good. Quite proactive on the part of the state. Apparently, the state is also concerned about sexual harassment.
Yes, sexual harassment in New York has recently been expanded quite a bit, and is really taking into account the rights of queer and gay individuals in the workplace, and has expanded sexual harassment protections to protections on the basis of gender identity, gender expression, and or gender presentation. So folks don't realize that, for example, like if someone in the workplace knows your pronouns, for example, and is actively going out of their way to misgender you, to hurt you in the workplace, that's actually illegal. That is protected under New York State sexual harassment law. And I think, unfortunately, transgender and non-binary workers are among the most likely to experience sexual harassment in the workplace.
Gabriella da Silva Carr, there is a whole other area. It's, I guess, sometimes called concerted action, and I think can involve just talking with your coworkers.
Yeah. So I think we don't really talk about concerted action. Like as a society, people don't often know that they do have rights. And, I have heard of people from the hotline, having employers who are saying like, oh, you can't talk about your wages. You can't tell people what you're getting paid. It's a secret. And that's actually against New York State law. Workers are protected under the law to be able to discuss their workplace conditions with their coworkers. And that ability to discuss those working conditions is covered under concerted action. And workers are entitled to be able to engage in collective action in the workplace. Whether that's talking about their pay, their working conditions, whether they want to talk about the need for creating a union, if they need to be talking to one another about issues they're having with their boss, that is all protected under concerted action. And if someone is terminated for engaging in concerted action, that is considered retaliation and can be reported to the National Labor Relations Board.
Well, we've heard a lot of cases about this. So I think you've also covered questions of the right to collective bargaining and to form unions.
Yes, I did talk about that a little bit, but I can go in a little more depth. So federal and state law guarantees most employees the right to join together with other employees for the purpose of collective bargaining, which collective bargaining is negotiating the terms and conditions of employment and engaging in activities together for mutual aid and protection in the workplace. This includes the ability to organize a union and join and support a union of their choosing, whether that's joining a pre-existing union, like the UAW, or if they're thinking about joining Workers United, or are they actually thinking about forming their own independent union, which is an option as well. Workers don't have to just join pre-existing unions. They can create their own union specifically for their field at their workplace.
When there are problems, well, I think you mentioned the National Labor Relations Board, and we've heard of some successes or partial successes there, but there is also, for other things, I guess the things that are based on state law, the place to go with a problem would be the Department of Labor. Now, some people think that if you go to a government agency, it's useless.
So I think it depends on what kind of case you have. You know, at the Worker Center, at our Workers' Rights Hotline, you can come talk to us about a workplace situation. And we use publicly available information. So we're really a mutual aid hotline. We're not a legal advice hotline. We're not lawyers. We're not claiming to be lawyers. Everything that we share is from information you could find on the internet if you did a really deep dive. That being said, you know, there's some cases where I would suggest speaking to a lawyer. If you have a smaller case, depending on your situation, or maybe it is a bigger case, but it depends on what it's for. Like, for example, if you were fired for trying to start a union in your workplace, I would absolutely say, you know, file with the Department of Labor and file with the NLRB. There are some cases where an attorney just can get a different result because the state has a different process and has a different statute of limitations within the Department of Labor. The Department of Labor can handle complaints within the last 3 years. For example, like if you've been having irregular paychecks and you have some missing wages, and maybe you're missing, you know, $500, $1,000, that's an easy filing with the Department of Labor to get resolved. It does take, you know, several months. It's not an overnight process. And, you know, the Department of Labor can only get you exactly what you're missing. So like the Department of Labor cannot pursue, you know, personal damages and suffering, you know, they can only pursue exactly what you've been missing from your paycheck. Or for example, if you're not being given breaks as regulated by New York State, or your employer's changing your pay wage, but not giving you a notification of pay and wages, which is required under New York State, you know, you can report that through the Department of Labor. If you're being denied overtime wages, you can report that to the Department of Labor. And they do an investigation, and then they assign someone to work with you on your case. And then there's usually a determination, and the state works, you know, with the employer to resolve the issue for the worker.
You mentioned the state minimum wage, but there is also talk in this community about living wage.
Yes. So a living wage is different than a minimum wage. A minimum wage is the state, you know, mandated minimum people must be paid. A living wage is the minimum salary that a worker needs to be earning to be able to cover basic needs as a single person. There are living wages calculations made for larger households, but at the Worker Center, we really focus our conversation, the advocacy we do around a single person's wage. And a living wage takes into factors such as the cost of housing, food, utilities, transportation, phone and internet, healthcare, recreation, savings, and miscellaneous expenses. It's not a thriving wage, that being said, for a comfortable quality of life. It is a basic sustenance wage. So basic needs only. And the living wage currently in Tompkins County is $18.45 an hour for a single person.
So significantly higher than the state minimum wage.
Yes, and we're also saying that's a basic sustenance wage. So, if I'm a single parent with two children, I need to be making significantly more than 18.45. Once you start adding children to the equation, the living wage starts going to $40 an hour and up.
Wow. I don't think there are that many jobs like that around here.
No, sadly, there is huge disparity in our community, and unfortunately, income disparity is seen across race and ethnic identities in our community. Black and Latino workers, Latina workers are more likely than any other members of our community to not have a living wage in their household.
It would be good to once again just remind people of the Workers' Rights Hotline. That's a phone number. You could leave a message there, also not about a specific problem, but also like, hey, can we have a presentation like this in our church group or whatever?
Absolutely. We would love to come and have a conversation in your community. A community outreach is something that we really would like to be doing more of. If you want a workshop, if you need someone to come and educate folks, if you're an employer and you have a question and you don't know who to go to, you can call us too. We're not just for the workers, we're also for folks who want to have a just and equitable workplace for their employees. And we always encourage employers to talk to us about whether or not they can become a living wage employer. But you can call about anything, or you have a friend who's experiencing something. I've sometimes had folks call, I've had folks call on behalf of undocumented immigrant workers who are scared to self-identify out of fear. Call, or I've had parents call for their children who are youth workers. I've had family members call for disabled workers that they're nervous that maybe they're being taken advantage of in their workplace. The Worker Center here, we're here for everyone. And we're really a place to ask questions and to seek information.
Okay, and that number is?
And that phone number is 607-269-0409.
One other thing that we've been hearing about is what's called at-will employment.
So I have to tell you that more than any other reason why people call the hotline is termination. And most people call saying, I believe I've been wrongly terminated in the workplace or unfairly terminated. And in New York State, that's actually pretty hard to prove because we're what's called an at-will employment state. That means that both the worker and or the employer can end the work agreement at any time for any reason, and both parties do not have to disclose why. This means that, unfortunately, in New York State, you can be terminated, fired, or laid off without any notice, and frankly, without being given a reason. People don't realize that at-will employment is the way of the land. Most people think that they should be given notice in the workplace the same way, right? Like most workplaces ask when you're going to leave, traditionally, right? We talk about 2 weeks notice, 1 month's notice. That's actually not required under the law. That's just something that as a society, we have developed as culture where the worker owes something to the employer. But unfortunately, at-will employment does give agency for the worker to be able to walk away, which is great, but it also gives the employer a lot of power to cut you off from your means of living at any time without notice. And, for most folks to lose their job without any notice means that they're going to scramble. And for some folks, that means losing their housing or not being able to afford medical costs anymore. It has some huge repercussions for folks when they get laid off, And usually getting laid off or fired is a pretty traumatizing experience for most workers because they're confused and don't understand what happened.
Is anyone trying to do anything about this?
So right now, in the city of Ithaca, there is the beginning of a just cause legislation campaign. And the hope would be that we would have just cause ordinances on the books here locally, and that there would be a committee that would review complaints of wrongful termination, and that board would make a determination, and the employer would be responsible for proving or disproving whether or not it was wrongful or rightful termination with cause. The burden is not on the employee, but rather the burden is on the employer to provide a case of why was this a termination that was necessary. There's many details to be worked out. The legislation has not officially come out, but it is going to be shortly. And we really hope that our community is part of groundbreaking works towards reclaiming workers' agency.
And I understand you can find out more about that on the web at justcauseithaca.org. Of course, it's still a good idea to call the Workers' Center because they keep the statistics. So even if you were on the way to resolving your own case, it would be good if they heard about it. I have been speaking about workers' rights with Gabriella da Silva Carr, Associate Coordinator of the Tompkins County Workers Center, where the number is 607-269-0409. This has been Ithaca DSA Presents. I'm Theresa Alt.
1, 2, 1, 2, 3.